On Saturday, June 12, 1993, Nigerians in their millions lined up to elect a president. The excitement was palpable. It had been precisely 10 years since the country last witnessed a presidential election. The feeling of transition to a democratic civil rule after 10 years of military dictatorship had revived an almost withering sense of nationalism among many Nigerians. But little did they know that their enthusiasm expressed through their vote will amount to nothing. The military junta of self-proclaimed President General Ibrahim Babangida had other plans. 2 days before the election, the Humphrey Nwosu-led National Electoral Commission appeared before the Transitional Council to brief it on preparations for the election, but was jolted when it was reportedly informed by the TCR it wasn't sure the commission could conduct the election. Tony Redia was present at the meeting. But the real drama that will file the outcome of the election to the archives of history was playing out in the court. A certain Justice Basi Ikpeme of the Federal High Court issued an order stopping the election on Saturday, June 12. The order emanated from a motion filed by the Association for Better Nigeria fronted by controversial politician Arthur Nzeribe and little-known Abimbola Davis, with Philip Umadi now let as their counsel.
I went to the meeting of the then National Security and Defense Council that met June 11 and pointed out to that august body that the court had no right to stop us.
But an undeterred NEC, backed by the extant electoral law, went ahead with the election, already creating the argument on the legality or otherwise of the exercise. Tuesday, June 15, 1993. 3 days after the election, with results already coming in, another order flew out of the court, this time issued by the then Chief Judge of the FCT High Court, Justice Mohammed Saleh. The order issued ex parte is very critical, restraining NEC from further releasing the results, which at the time had clearly indicated MKO Abiola on the lead of votes. Civil rights lawyer Femi Falana was deeply involved in the legal drama.
There were two other conflicting orders of court. One issued by Lagos High Court, I think Joseph Lugbani, another one by Judge in Benin, Edo State High Court. But the Court of Appeal was already seized of the matter, and all prayers by the Ibrahim Babangida junta to influence the judiciary at that appellate level failed.
Strangely, the certified true copy of the previous order was not immediately available for a notice of appeal and possible motion for stay of execution to be filed. NEC was left frustrated.
I believe that the Court of Appeal will have, set the law and, will have guided the lower courts so that those conflicting orders will have been taken care of.
Wednesday, June 23, 1993. A statement from the military government suspends the National Electoral Commission and the entire transition program. The June 12 presidential election had become a futile exercise.
2 days for Kaduna Court of Appeal to meet, my commission was disbanded. I was no longer chairman. What should I have done?
This is the Federal High Court in Abuja. What strikes you first on stepping in here is this imposing, gigantic, copper-colored statue, the Maiden of Justice, which presupposes that all manner of men that come here will be treated fairly. But many Nigerians had cause to believe that presumption was seriously maligned. 20 years ago, a well-orchestrated political drama which will serve as the albatross of the June 12, 1993 presidential election was staged in the courtyards of the judiciary. So much has changed ever since then, yet questions still remain. Unfortunately, some say the judiciary is still confronted with problems of executive interference independence, and worst of all, corruption.
But the question of financial autonomy has not been seriously addressed. Under the Constitution, the judiciary is also supposed to be financially independent so that we can genuinely guarantee and prevent any interference in their affairs. That has not been done. Apart from that, the judiciary, our judges have not come down heavily on those who interfere with their judgments or administration of justice. And that is why people blame the judiciary, including politicians who attempt to influence the judiciary. Once you do not dance to their own tune, you are immediately accused as a judge of having taken money from the other side.
The current leadership of the judiciary appears committed to present a new and reformed judiciary.
Under my watch, there shall be zero tolerance for corruption, zero tolerance for subversion of the political processes, zero tolerance for indiscriminate abuse of the equitable remedy of injunction. We shall sustain the current efforts of the National Judicial Council, which I chair, in weeding out the bad eggs that smear the image of the Nigerian judiciary, and bring opprobrium to an institution whose role makes the difference between the rule of law and jungle justice.
How much of these reforms are sustained will determine whether or not the mistakes of the past have become a useful lesson of history. Utibe, AIT News, Abuja.